Wow, this looks pretty empty.
Well, everybody's gone.
Yeah.
They heard it wasn't about water management.
Please,
Nobody's interested in you fellas.
please have a seat. We can begin the case of LACKNER versus Central Florida Investments.
Thank you, Your Honor. May it please the Court. My name is Nick Shanine, and I represent the appellant in this defamation case, Ms. LUZ Angela LACKNER. I would like to save 5 minutes of my time for rebuttal. Ms. LACKNER was a timeshare leasing representative with the defendant, Central Florida Investments, CFI. After she'd received awards, commendations, served her job there well, she was abruptly fired when she was defamed by CFI management, who told other employees that she was fired for dishonesty because she allegedly attempted to obtain commissions, plural, to which she was not entitled. This is the defamatory sentence that was repeated again and again to different employees, but because of 3 separate and distinct legal errors, rules of law that were enunciated by the court below at the invitation of CFI, those 3 legal errors, each one of them led to a result where despite many days of trial testimony, the jury did not get to receive the evidence and did not get to do its job as the trier of fact. Ms. LACKNER?
Before you go any further, Mr. Just sort of out of curiosity, I see that this was tried by a magistrate. Now, I guess, been out of circulation for a while, but I have not heard of that. Magistrate trying a jury trial, is that by stipulation of the parties?
Judge Cobb, you are correct. It is not a normal or common circumstance, except it is allowed when, by stipulation of the parties, they agree to a magistrate judge. In this instance, the business court in Orange County, the progenitor of the business court concept, had an overfull docket. There was no hope of this case that had been lingering since 2002 is when the case was filed.
What are the qualifications for the magistrate? Is this?
I know the magistrate judge
has to be a lawyer?
He does have to be a lawyer. He's appointed. I happen to know this particular lawyer before he became a magistrate, and he's an excellent lawyer. There's no question that
I didn't mean to interrupt you. I was just curious. That was...
No, but, and unfortunately, it does...
I have not seen that before.
Judge Cobb, it does go to part of the underlying issue that's here, and that's because it's a magistrate judge who gets drafted in to duty. It sets up a situation where he is particularly vulnerable as the court to being put in situations where arguments are being posed to him, invitations, in fact, to err, and without the length of backdrop that the actual judge might have had over 5 years of litigation, in fact, the prior judge had denied motions for summary judgment on almost the exact same legal theory, the theory that you can't have intra-office communications. Here, because it's a magistrate judge who didn't have the prior case experience on this particular case, it's easier to understand how that invitation to err might be accepted.
Your client is suing for slander. To whom was that slander communicated?
That slander was communicated in a number of instances between managerial employees at the place that she worked, CFI, to other employees, be they management or otherwise, inside of CFI. It
wasn't communicated to any non-employee, right?
It may well have been.
There's no evidence.
That is not the evidence that was presented at trial, the concrete evidence. It's believed that there was communications outside of CFI. But
so the trial court's theory, if I'm reading this, and I didn't have a lot of time to read up, but if I'm reading this correctly, thought that there had to be evidence of communication of the slander outside of the corporate employees. Am I reading that right or not?
You are reading it correct. That was the argument that was posed to the judge that you
said. That was the argument that
and that was the argument he ultimately accepted. That you
disagree with that. What is your best case in opposition to that theory?
Interestingly, the best case, it's actually 2 linked cases, comes from this very court. This court had decided back in 1980, the case of Glenn versus City of Kissimmee, that's 383 Southern 2nd 774, where in that case...
Wait a minute, give me that site again.
Certainly. It's 383 Southern 2nd 774, 5th District.
Is that Judge Sharp's opinion?
Your Honor, I honestly don't know whether it was Judge Sharp. I hope it was, because
doesn't matter.
Known for a good opinion, and this one we rather like. And
that's one. What's the other?
the other one it cites that case in a very, very succinct fashion, and it's Southern Bell versus Barnes, where the 3rd DCA cites Glenn, and the cite for that, Your Honor, is 443 Southern 2nd, 1085. But rather than look it up, I can read you exactly
now
the
those
one law
stand
that
for the
matters.
proposition that the communication does not have to go outside of the corporate ranks.
That is correct.
Okay.
And there are, of course, each of these cases talk about the fact that those communications could ostensibly be entitled to a qualified privilege. And we don't argue that the defense wasn't allowed to argue a qualified privilege. And in fact, this goes to two of the other issues in the case. The defense most certainly did have its affirmative defense that there was a qualified privilege that would attach to these intra-corporate communications, and they were free to argue such a thing.
Would a publication by a managerial employee to another managerial employee be actionable if the statement was made with malice?
Absolutely, Your Honor.
You have to show the malice, though.
We would have that burden to show the malice, and that, of course, is part of the other problem with this case. That there were two other rulings of law that were also inaccurate, and those rulings of law, one of them was that we couldn't even talk about the word malice. We couldn't get to the word malice because the judge accepted the invitation to this non-existent.
He said you could only bring that up on rebuttal?
Correct.
Did he, or has your opponent cited some authority for that?
There is no case.
That was news to me, but I've been away for a while.
Judge, the law then and the law now is the same. The practice is the same. Affirmative defenses are fair game. They need to be fair game. The idea of, say, an average tort case where the affirmative defense of comparative negligence is going to be brought, the idea that a plaintiff is actually not going to have any discussion of his actions because they're not yet relevant until after the defense goes, A, is simply not the law, but B, would make trials as unwieldy and as workable as this one proved to be. It's the equivalent of trying to play password where you suddenly can't say certain words, you can't say all these things that have to do with the very crux, the core of the case. It's simply not the law, and when the judge accepted that invitation to err, it effectively hamstrung the plaintiff to make it unable to effectively put the case forward. And unfortunately, while he tied one arm behind his back, he actually tied the other arm too with an equally non-existent.
In this case, Mr. Shaneen, is it relevant or not as to whether your client, LACKNER, actually earned the commission or did not earn it?
I believe it.
Or does it matter?
I believe it does matter, and it would have mattered if we'd gotten all the way through the trial because one of their defenses was truth. They were going to argue, so it appeared, and so some of the cross-examination seemed to imply, that they were going to argue that, in fact, she had been inappropriately taking this $130.
What was the evidence that she had earned it? Wasn't there evidence from Gonzalez that she did not?
That was one bit of testimony that had to be countered against hers, Mr. Ramirez's, and the other individuals who testified about the way that the $130 was almost a gratuity. It wasn't something that had to happen.
Ramirez's testimony, you contend is favorable to you.
I believe that the record definitely has it being far more favorable to LACKNER. And of course, the ultimate problem with this is what we're talking about here is questions of fact. Was it true? Was it not true? Was it a qualified privilege? Was it not? Was there malice? Was there not? All of this is the core of what goes to a jury. And when a judge decides to snatch it from the jury on directed verdict, as this Court's very aware with the Danea Highlight case and every case that's followed, that all reasonable inferences had to be made in favor of the non-movement for directed verdict. And in this case, there are all these issues of fact that need to be decided by the trier of fact. And in fact, that's specifically what the 3rd District's Aronston versus Smith, 311 Southern 2nd at 739 case holds, is that it's specifically a jury issue as to whether persons to which a statement were made were entitled to a qualified privilege or not, whether all of these issues are issues of fact that a jury needed to have gotten, and it was wrongly taken from them. And it's unfortunate that we're going to be now the trial was already 5 years after the suit was filed, and now we're going to be that much farther delayed, and time is not the friend of the plaintiff. But that said, she is entitled to her day in court, and she's entitled to have this case be returned so that we can do this without the erroneous application of the publication rule, so that we can do this without this interesting but non-existent rule about you can't bring up evidence outside of your case in chief that are related to non-withdrawn affirmative defenses that are currently in play by the defendant. And that you can't, the idea that you can't have any discussion of the termination because it's a defamation case that centers about the statements made about a termination, just because it's not a wrongful termination case. That's also simply a rule of law that can't be found in any case, doesn't make any sense, and it was also part of the reason why this case ultimately could not go forward.
So what are your damages?
Ms. Lackner was unable, first of all, she had a lot of emotional trauma. These are her friends, these are her colleagues, these are her coworkers who are now being told that she's a liar, a thief, a cheat. These were damaging to her. Her emotional stress was evident in her testimony that she was able to state out there. So we believe that the damages are in at least that respect significant. Her length of time that she was unable to work afterwards, it's up to the trier of fact, we believe, to decide whether or not that was something that was causally related to these statements or not. And then ultimately, these are per se allegations, and therefore damages are to be presumed in one form or another. So we believe
You're claiming this was slander per se, and you need not prove actual damages.
I believe that's the law bears that out very well. So we do believe that this is
Was Sanchez a managerial employee?
Sanchez was actually a non-managerial employee. He was
What were his duties?
Sanchez worked on the floor, and his duties were similar to Ms. Lackner's. Barnett, who talked to Sanchez, was the sales manager. Ramos was also the floor manager, and Sanchez was below him. So it would be an argument to try to equate Sanchez to some sort of quasi-manager. But even if they wanted to make that argument and they wanted to argue that he was quasi-managerial, again, that goes, as made by the Aronson versus Smith case, to the question for the jury to decide, is this a situation where that privilege exists and that privilege has been exceeded or met? And in this instance, the jury was simply never allowed the opportunity, despite getting to sit through some rather lively and interesting testimony, the opportunity to then weigh in and make their decisions on that testimony. So because of the three different rules of law that weren't rules of law, and because the directed verdicts were granted in error, this court should use its de novo review to correct the error and allow Ms. Lackner her day in court. I would reserve the remainder of my time for rebuttal.
All right, you have about 7.5 minutes left.
Thank you.
Good morning. May it please the court. I'm Richard Epstein. I'm with the Greenspan Martyr Law Firm. With me at the council table is Victor Klein, who is on the brief in this matter. We represent the Appalachee Westgate Resorts. I will say in a word, befuddled. We have just heard the appellant's argument here about what the perception of the plaintiff, of the appellant, was concerning the impact of these statements that were supposedly made against her. And quoting precisely what counsel said, it was when the court, when I think Judge Monaco asked what were the plaintiff's damages in this case, he said that it was her family and friends and co-workers hearing this statement again and again and again. The problem with that characterization of this case is that that is nowhere near representative of what the evidence that was actually adduced at trial was. There were no friends that testified other than two co-workers, one of whom, the court may note from the record, was significantly impeached by a demonstration that, in fact, on the day he testified he heard certain things, he wasn't even at work on
Well,
that.
impeachment wouldn't matter with regard to a motion for directed verdict.
No, it would not. I agree with that entirely.
Let me ask you this. If a managerial employee tells 10 employees, and it's undisputed, a managerial employee gets up and says, I told these 10 employees, the defendants, the plaintiffs are crook, or whatever it is, a defamatory, a slander per se statement. Do you need those 10 employees to testify, or is the evidence sufficient to support award of damages just by that managerial employee saying, I told these 10 employees that the plaintiff was a crook? Assuming it's false.
Okay, well, you're presuming evidence that never made it into this record, and that is the testimony of the manager that he said that. In this case, there was no testimony from that manager. Joe Barnett...
There was testimony from a third person that the managerial employee told other employees this. Correct?
Okay.
Is that correct?
No, I disagree with that.
That is correct, though.
Excuse me?
That is correct.
There is testimony that Ramirez himself said he said something to several people. He could only remember one of those people. Now, is that alone, standing alone, sufficient to establish publication? In our view, the answer to that is very simply no. The statement this falls within the category of circumstantial evidence of the statement. The mere fact that someone says they said something does not close the loop. The law with respect to publication is very clear. And this is what's interesting about the entire argument that the appellant has fashioned here, is that they don't cite to the cases that actually deal with publication and the cases that the court actually relied upon. The court relied upon Smith versus Anheuser-Busch Brewing, in which case the court did find, the first ECA did conclude that the statement of a manager to another manager talking about a matter of explaining their own actions or the company's actions was not publication. And in fact, the case that the appellant cites to support their entire claim that this is not a good rule of law doesn't say that at all. And I'm turning to Glynn versus the City of Kissimmee, which is a decision of this court. It does turn out to be Judge Sharp, Judge Cobb. And this is a quote from the case as to what the holding of the case actually is and relates to. We do not determine whether words spoken to appellants by a manager in the presence of an assistant brewmaster constituted publication to the assistant, or whether that communication was privileged. In fact, the case that appellant is relying upon specifically excludes the holding that the appellant is citing it for. They're saying it is not their decision, and the court then goes on to talk about the qualified privilege, which would operate in the event there was proof of publication in this record. We only get to qualified privilege if, in fact, the plaintiff had first made their prima facie case. And this is, Judge Cobb, with the greatest of respect, this is where we seem to have gone off track with respect to this qualified privilege issue and the proof of malice. What we need to look at here is what is the plaintiff's prima facie case. Their prima facie case is to prove that a statement was made, that that statement was false, and that that statement caused damage after it was published. That's it. Nowhere is the proof of malice a necessary element of the plaintiff's case. That is the explanation for what Magistrate Judge Glatt did. Simply put, malice was irrelevant on the plaintiff's side of the case, and it could only be adduced in order to prejudice the defendant. It had no bearing on any claim that was maintained in this case. It was not an element of proof for which the plaintiff had the burden of proof. So there was...
Isn't it evidence of malice, Mr. Epstein, if this was an employee at will that could have been fired for a whim, as I understand it? They didn't need causation.
That's true.
Why isn't it malice to instruct other employees and workers to spread the word that she was fired for trying to steal a commission?
Okay. Well, it kind of you're begging a question. Why is that, and I don't mean to answer your question with a question, but why is that relevant? The termination is not being challenged in this case. This was not a case where she had a contract and there was an allegation.
She could have just been fired. They didn't have to then spread the word that she was fired for dishonesty, but they did.
If that was the goal or the objective to simply terminate her, then perhaps that's true. But what happened in this case was, in fact, warranted by the facts. You know, and if we're kind of segueing into an area that I think the court has already grasped, and that is that the only eyewitness to the events that led up to her termination was the purchaser, the prospective purchaser. And that purchaser,
Gonzalez, wasn't it?
Gonzalez, yes, Mrs. Gonzalez, who testified truthfully, nobody had any challenge to the veracity of this particular witness, that in fact, the plaintiff did not contribute to the sale, and that was the basis for a determination that could have been made if it had gotten this far, that in fact the reason stated was a very legitimate and accurate reason.
Let me ask you, requesting a commission when you're not entitled to a commission, is that the same as being a thief?
No, she wasn't accused of being a thief.
Or attempting to steal a commission?
She wasn't accused of attempting to steal a commission.
She was accused of?
She was accused of dishonesty, because that is the terminology that is used in the employee manual upon which the stated reason in the personal form was derived. So it was dishonesty in connection with work, and the facts were...
So if you had a close call on whether someone's entitled to a commission or not, or how much of a commission they're entitled to, and a person is determined to be wrong, then they're dishonest?
No.
Well,
everything would be a case-by-case basis, you know, and that determination, whether in fact she earned this commission or not, was a determination that was made by, in fact, people, I think the evidence showed, people other than Joe Barnett, and certainly people other than William Ramos. William Ramos, who, just to correct the record, is in a completely different department from Ms. Lackner. The two people that supposedly hated her, one is in a completely different department, and the other did happen to be one of her bosses.
let me ask you this. You said the malice is irrelevant to proving the three elements you mentioned.
Of the defamation claim, that's correct.
Okay. Well, you know, it seems to me that if I'm a juror, and I'm sitting here and I hear testimony that the plaintiff is a wonderful person, has been a wonderful employee, and that all of a sudden she gets fired because of this incident, I'm going to assume that, gee, you know, there must be some truth to the defendant's position that she was dishonest, because why would they otherwise fire an employee that everyone says is wonderful and has been a good employee for all these years? Now, on the other hand, if I heard that there was a manager who disliked her and was looking to get her, etc., then maybe I view whether it's true or false statements a little differently. So I don't quite understand your position that the malice is totally unrelated to the proof of the other elements. I mean, why wouldn't that be? Why wouldn't a juror want to know that?
Well, what a jury may want to know, as we all know from Evanston...
Why wouldn't that be relevant?
Okay, it isn't relevant. That's the problem with your question. It assumes that there is motive or intent that is implicated in a defamation claim. There is not.
Would you agree that if there was no indication that any management employee disliked had some personal animosity toward the employee, that would tend to show that it's more likely the allegation was true? As far as
that if no employee had any...
Yeah, if you had two scenarios. Scenario number one, plaintiff is fired, and it's alleged she's fired because of this incident. It's alleged that during this incident she was dishonest. And you hear that up until this incident, management thought she was a wonderful employee. And then you have scenario number two, where everything's the same, except you hear that there's a couple managerial people that dislike her. I mean, you're saying that's not relevant to determination of...
It has nothing to do with the elements of the claim. Now, the problem is...
Does it go to the bias of the witnesses?
We're conflating...
Does it go to the bias of witnesses testifying?
Absolutely, but neither of those witnesses testified. Barnett, they didn't call Barnett. They didn't call Ramos. Remember, the plaintiff has the option to call all these people. Remember also, they didn't call a single person who Ramirez supposedly talked to. They could have done all these things. We're assuming that all of this evidence existed when, in fact, this evidence did not exist because the plaintiff chose not to present the witnesses. Nobody truncated the case from the standpoint of not allowing witnesses who were present and ready to be called to testify. They chose not to depose these people. They chose not to produce them at trial. So they can't now criticize what these people might have said if, in fact, they had testified, because they chose not to call them.
Let me ask you this. Are you aware of any case in Florida or anywhere in the country where it's appropriate, where it's been found by an appellate court that in a defamation case, the plaintiff could be prohibited from putting on evidence of malice until the defendant had put on evidence of qualified privilege?
Okay. We're dealing with the qualified privilege defense.
I'm asking you, are you aware of any case that supports that decision?
Yes, sir.
Okay, what case?
We cited, it's Linnefelt versus Beverly Enterprises. It's a first DCA 1999 case. This deals with the qualified privilege, and it states that qualified privilege is an affirmative defense. And then it goes on, and I will quote, plaintiff must first demonstrate a prima facie case of defamation before evidence on the qualified privilege is permitted. That's the distinction between simply stating some, generic affirmative defenses and this particular affirmative defense in this particular case. When you have an affirmative defense that does not implicate an element of the claim and is only triggered once the plaintiff has made their prima facie case, then you do have an appropriate ruling on an evidentiary basis as to what the order of the evidence should be. The plaintiff should not be able to presumptively put on the defendant's case because they want to make the defendant look bad. The defendant should focus...
You mean you cannot, and the plaintiff, this is, I'll say, news to me, the plaintiff cannot present evidence in rebuttal of one of the affirmative defenses until after it is presented?
A pled affirmative defense?
A pled affirmative defense?
The plaintiff's case
is limited... for a yes or a no.
If it's not relevant, no. They should not be putting on irrelevant testimony. But
it could only be relevant, you're saying, once the evidence is presented to support the affirmative defense.
And in the case of qualified privilege, because that's all we're dealing with here. We're not dealing with a broad statement or rule of law. We're dealing with a specific defense, which is the entire focus of their appeal. We're dealing with a specific defense. In this particular defense, the testimony that they want to adduce has no relationship to their prima facie case.
And what is the case you say supports that?
Well, it deals specifically with a qualified privilege. Linnefelt versus Beverly Enterprises. It's a first DCA 1999 case.
All right, and what is the site?
I didn't jot down the site here.
Okay, well, what's the name again?
I had it was Linnefelt, Linafelt.
It's in the briefs, Warren.
Okay. And also Spears versus Albertson and Glynn versus City of Kissimmee, cases that have been cited by the plaintiff, both characterize this defense as the defendant's burden of proof to prove it.
Well, let me ask you this. So I could foresee a case where in the plaintiff's case, they have to put on evidence that would support the existence of a qualified privilege. You put on evidence of the defamatory statement. When did you hear this? Well, the manager was telling the employee that, the plaintiff was dishonest in response to a question about why isn't the employee here today? So that might already come into evidence which would support the giving of instruction on qualified privilege, which the plaintiff has to present on their own. Now, why shouldn't the plaintiff be allowed to show, however, the manager knew this was not true, this was based on malice, etc.? I mean, that evidence might come in through the plaintiff and not through the defendant.
basically, it becomes, a trial strategy issue. A defendant does not have to pursue every affirmative defense that they raise, just like the plaintiff at trial does not have to pursue only those claims that they choose to bring before the jury. So, what you're suggesting, Your Honor, is that the defendant in its case is not bound by what the plaintiff has proved. They could put on evidence of any claim that the plaintiff has asserted, even if they abandon it at trial.
Let me ask you this. In this case here, if instead of granting a directed verdict, the magistrate, the judge denied it and said, okay, defendant, call your first witness, and you say, we rest, would you be entitled to have the jury instruct on qualified privilege based on the evidence they heard in the plaintiff's case?
Arguably, yes, because it is clear that testimony came out during the plaintiff's own examination of witnesses that bore upon the privilege. For instance,
well, then if you would be entitled to that instruction, then why wouldn't they be entitled to put on malice to overcome that privilege?
because we may not want that defense. That's the whole point. If they adduce testimony that may bear upon our affirmative defense, we may not argue that defense.
Counselor.
That still remains our choice. We can't have that choice forced upon us.
Counselor.
Yes.
Isn't the definition of relevant the issues framed by the pleadings?
Ultimately, in a discovery context, of course, but at trial, when...
I think in any context.
No, I believe...
The pleadings define what is relevant for the case, and you pled an affirmative defense. I don't understand, I really don't understand this whole business, so they can't put on any evidence of it.
Okay. Well...
I'll admit that's the first I've ever heard of that. I've been around a long time.
An affirmative defense of this sort requires a specific showing, and it requires a specific showing...
What's so bizarre about this affirmative defense?
It's developed that way under the law of defamation, where basically if the defendant claims it had legitimate business reason to do what it did and say what it said, then they can look at the motives. But until the defendant says that, motive, i.e. bad faith or malice, really doesn't come into play. And consider this, and it goes back to the point I made originally, okay? This was not an issue of whether, in a generic sense, evidence of affirmative defenses can come in the plaintiff's case. What was argued to Magistrate Judge Blatt about malice is that it had no bearing on the plaintiff's claim itself and could only be prejudicial to the defendant. And because there would be no point to it otherwise. If we chose not to assert this defense later on in the case, then that malice would be hanging out there for no reason at all, and it wouldn't link up or connect to anything except that the jury would have heard it, and there's no way to unring that bell.
So going back to my hypothetical, they rest, the magistrate denies the directed verdict, you rest, and then you get talking about jury instructions, and you say, I want the jury instructed on qualified privilege. They get to say, well, Judge, we get to reopen the case because they've now raised it? No. We're going to be bound by whatever the record is. Well, if they... let's say there's enough in the, you've already acknowledged there's enough in their case to allow the issue of qualified privilege to go to the jury. So why... Then let me tell you what, in fact, happened in this case that we're talking about. I know it happened. He granted the directed verdict. My question is, your position that you've argued to us today is that they can't put on malice until you've put on affirmative defense of qualified privilege. If the evidence has already come in to support a jury instruction, and they rest and you rest, and now all of a sudden you say, we want the jury instructed on this, I'm asking you, do they have a right to say, Judge, now that they've raised it, we want to go put on evidence of malice? No, because they put the testimony on, they adduced the testimony, they opened the door, and they had every right to put on all the testimony. Again, a strategic decision was made not to put on the testimony. And oh, by the way, Your Honor, the testimony that they claim was excluded wasn't. Both Sanchez and Ramirez testified about the animosity that Barnett and this guy Ramos supposedly had for her. In fact, Ramirez testified specifically about the incident that supposedly gave rise to it. So they were not excluded.
You're way over time.
Thank you, Your Honor.
All right, appellant, you have 7 minutes and 33 seconds.
I assure you my goal is not to use it all. Thank you, Your Honors. Briefly in rebuttal, first, as this Court has pointed out, this is simply not the way that any of us have experienced trial practice. Trial practice allows and requires for the pleadings to define what the parties are to do. If a defendant doesn't want something to be in play, there is a very easy thing for that defendant to do, and that is to withdraw that affirmative defense. By having that affirmative defense available throughout the course of the trial, it is impossible, as Judge Evander has pointed out, to go forward and not have discussion of this. And in fact, the very argument that's now being posed here is that somehow there was still enough discussion during the plaintiff's case, even with both hands tied behind the plaintiff's back regarding the inability to talk about these things, that there's still, the overlap is absolutely unavoidable. You cannot have a trial run this way, and as much as the argument was, well, this is a very special rule for qualified privilege only, even though obviously the case law doesn't bear that out, that if you can't limit it to just qualified privilege, that if you look at all of the other affirmative defenses, if trial were now to be practiced in this way, it would make the ability for plaintiffs to proceed knowing what it is that they are to prove and what they are not to prove impossible. Trial judges would be put in impossible positions routinely attempting to arbitrate these decisions. The argument was made that this Court should rely on this case of Smith versus Anheuser-Busch instead of this Court's own precedent in Glenn. The Anheuser-Busch decision was made by the first DCA in 1977. This regards the whole publication question. The Glenn case, decided in 1980 by this Court, by Judge Sharp, referenced specifically the Anheuser-Busch decision, and it said that the trial court below had ruled that no publication of the slander took place because the communications were between employees of the same employer, citing Smith versus Anheuser-Busch. The case that was just told to you was relied on by the trial magistrate judge in this case. The fifth DCA had to say that the Smith case did not reach that question, and then the Glenn case went on to hold the opposite. And in fact, the Glenn case said because we find there was a material issue as to the availability of a qualified privilege for the alleged slanderous communication, we reverse and remand for trial. Intra-communications inside of a company are absolutely game, that they are subject to arguments of qualified privilege once raised as an affirmative defense, which was done in this case. And the allegation that Anheuser-Busch, the case relied on, is somehow stronger than the Glenn case that specifically said, we've read that case and that's not what that case says, that simply doesn't follow.
Opposing counsel cited to the Linnefelt, the first DCA case. You distinguish that case?
I find that curious, and here's why. The Linnefelt case was quoted in their brief as part of a lengthy string cite. The string cite was not anywhere in the portion of the brief regarding this argument. Their string cite regarded an issue of falsity, which isn't really even an issue before this Court. And their string cite parenthetical reads as follows: affirming directed verdict for former employer who told plaintiff's prospective employer that plaintiff had submitted a false timesheet where statement was truthful. Well, that case, obviously they didn't put that case forward as a case that said what they're now attempting to have that case say, and this Court has been unaware of any other instances of affirmative defenses being somehow immune from examination during a plaintiff's case in chief. Moreover, the Linnefelt case appears to regard that more special situation where a statement is made in an HR department to another HR department, where the qualified privilege perhaps rings the most true. And even in those circumstances, though, it would appear that the qualified privilege is, as by the first DCA's own statements in Aronston v. Smith, that's a statement for the jury. Those are issues for the jury. So when Mr. Sanchez testified that his manager, Mr. Barnett, told him that, and the quote is from the testimony, he came one day into the office and he told me that Mrs. Lackner had been fired because she had tried to steal some commissions and to make sure that I tell other salespeople that that had happened so that wouldn't happen again in the company. This is exactly the root of the defamation that was suffered by Mrs. Lackner. Mrs. Lackner had a right to have this case heard by a jury. The evidence was before the Court, and yet it was taken from the jury because of the unfortunate applications of these 3 different invitations to air, each one issued and argued passionately before the judge. And then the objections were made routinely by the defense each time the plaintiff would attempt to approach these issues of any sort. So those objections came during the opening statement. Those objections came during the course of trial. There was argument by different trial counsel that if the next witness who comes up says anything about this, we're going to move for a mistrial. The magistrate judge became more and more hamstrung by this ruling as the case went on, such that late in the trial the judge then said that, but as an affirmative defense, you can't sit back and say, here are my affirmative defenses, oh, by the way, the other side can't put on any evidence against them until we put on evidence for them. You either withdraw them or they are before this court. The magistrate judge came up with that correct enunciation of law, and unfortunately, then the argument was, wait, but Judge, that was opposite of the way you've ruled, and you can't go back now, and the judge realized, well, that's correct, I can't go back now because too much had been done. And that goes to one last issue on rebuttal, and that is the fact that the primary rulings on this came 2 months prior to the trial as a result of motions in limine. And as a result, there was argument, well, they could have brought this witness or they could have brought that witness. And in fact, we already knew what the rules were. Whether we agree with the rules or not, the pretrial ruling of the court was clear. We were not going to be able to put on this kind of evidence. And so bringing on witnesses who could talk about those witnesses, that evidence just couldn't and wouldn't make sense. The plaintiff was unfairly prejudiced throughout the trial by these pretrial rulings. The plaintiff was unfairly prejudiced during the trial by these pretrial rulings, and the plaintiff was ultimately denied the right to a fair trial before a jury of her peers when the judge improperly directed a verdict against her. Your Honors, we thank you for your time and attention today.
Thank you, gentlemen. That concludes our docket for today, and we are adjourned.